Right, I'm going to make a start. This is the fourth presentation. Thank you so much for coming tonight. You'll be relieved to know this is it. This is the final one. To give you a summary, I've been through leadership, strategy, innovation, and today I'm doing, I say every week is the big one, but this is another big one. This is marketing. If you do an MBA, you'll be on the receiving end of an obligatory course in marketing wherever you do it, because there is a national curriculum for the MBA, believe it or not. Or you could become a BSc student in marketing, or you could even do a master's in marketing, or you could even do a master's in new media, social media, and marketing. Or you could decide to become a member of the Chartered Institute of Marketing if you're really into marketing. So, guess what? Tonight's workshop is on marketing. There's a lot to cover, and hopefully, I'm going to try to get through as much of it as possible. Uh, um, that is not right remote control. This is one last plug for the Facebook page and one last plug for the Twitter page. Yes, I'll be actually mentioning Twitter right at the very end of this seminar, which is due to end at about 7:10 tonight. I'm sorry about the late start. I would strongly recommend Sonia Society, which is the BPP Commercial Awareness Society. That's different to our society. Our society is much smaller. This is the Legal Awareness Society. I explained this before, but I'm looking at things from the perspective of the client, not the lawyer. And in other words, there's going to be a lot of focus on the business plan rather than the law needed to implement the plan. But hopefully, as lawyers, you'll appreciate what the plan is in the first place, which will probably help you have some real feel for the objectives of your client. And as you know, if you don't know already, when you apply for a training contract, they'll be looking for your business commercial competence for reason that a lot of their clients are high value, high wealth clients, and they ultimately, indirectly, pay your salaries. So it's quite a relief to come to an end with this topic because the issue here is that this topic really makes sense of a number of things we've done, which have been, to remind you, leadership, strategy, and innovation. The actual structure of the potted introduction to marketing, by mind, this can be a 3-year degree, is as follows. I've been quite selective about what topics I wanted to do, and if you're interested, go down to Gow Street, Waterson's, and pick up a book on marketing. I suggest Kotler. It costs about 40 quid. Buy it off Amazon if you're interested. But the good news is, if you're a student at BPP, I think you can have access to it online free of charge, if you're interested, but I doubt you'll have time with your other SGSs, etc. So the plan is as follows. 7 Ps, in case you haven't heard of this, 7 Ps are the features of the product you're trying to market. And I'll try to explain that. That is quite a well-known thing in marketing. If you go onto Wikipedia, you'll find a page on it, but that's not, of course, the arbiter of what is important. If you go to the Chartered Institute of Marketing, you find a very helpful guide to it. Market segmentation, that'll be obvious when I come to it. How you price a product is of interest, whether in the public sector or the private sector. Localization, is many of you, whether you know it or not already, will be dealing with international clients, many of whom are operating across certain jurisdictions in particular. Now, I did mention this issue in strategy, but I'll come back to it again. And 5 is how you enter new markets. Possibly the nirvana for marketing is, or rather the holy grail for marketing, is to try to find new customers, akin to a law firm trying to find new trainees in their training contract. Uh, they're always seeking a new customer, new business. And the final topic tonight is social branding and social networks. I've been talking this week about the pearls of being on Facebook and Twitter as a law student. I'm not going to talk about that, but I'm going to talk about why this topic is considered interesting to law firms, actually. And it'll be interesting for the PLCs you work for, or even high street clients you work for. So that's a nice way to round off, really, the entire month of commercial awareness. I'm going to come on to the 7 Ps. If you're anywhere near the CIM website, you'll be able to download the booklet on the 7 Ps. I have emailed all the people who are coming or not coming, in fact, to the workshops, a full handout. I could argue that I shouldn't give you a full handout so that you're encouraged to come to listen to this talk, but really I'm not that manipulative, so please bear with me. The product is essentially your core offering. In other words, what you intend to do to fulfill your customers' needs. And a pithy definition of it is that the perfect product must provide value for the customer. And actually, furthering this, it could be intangible or tangible. The price obviously impacts upon the buyer's satisfaction. If you feel you're being sold a bit of a pup for a lot of money, you're not going to get that much satisfaction about it. And the way this is generally perceived in marketing is that the product is only worth as much as customer is really prepared to pay for it. But I'll come on to some sort of important provisos about that, and really essentially distinguish between cost, price, and value. And if you maybe did economics for A level or did even through university, you'll know exactly what I'm talking about. Fee is a product that you have on offer. I'm not going to have time to talk about many things. One of the many things I won't be talking about is market positioning. That is where on the scales you view your products as different from other people. You'll hear people on Dragon's Den and BBC Apprentice talk about the unique selling proposition. What does your product do which other products on the market don't do, pardon the double negative? And pace. Uh, Clearly, it's important to provide your product in accessible pace. If it's not accessible, then forget it. Now, when you come, if you already have come on to the commercial law and intellectual property elective, you'll be talking about distribution agreements that'll be relevant to you, where in fact you're marketing your product is interesting also for a number of different reasons, which will come apparent to you in your electives on the LPC. People. Now, obviously, which people are fronting the service delivery might be a surrogate marker for your operational efficiency. Processes It helps if your project's being seen to run smoothly. If you spend a lot of time on the front line to the complaints department, that's not good from a marketing point of view, obviously. And physical evidence, well, I think the best way to explain that one is if you were to go into McDonald's and they, well, let me refrain from using specific examples. If you were to go into a restaurant and the calorie is dirty or the product didn't look that hygienic, maybe more appropriate for a kebab shop in West London, that physical evidence is how much you're attracted to your particular product. So that was a rather superficial view of the 7Ps, crucially important for any product and service particular company wishes to offer. And you remember that a company, given Section 172, enlightened shareholder value, is seeking to enhance its profitability. Market segmentation, again a rather trite diagram, but this is an idea that the people you're selling to aren't all in the same boat. And actually, they all have different selling purchasing powers. Some will be richer than others. It could be the case that some of them located in the north of England for a particular product or the south of England for a particular product. And this bears relation to your interaction with the customer. Now, my first degree was in neuroscience, and that's what my PhD was in. And I came on to decision making in my first talk. And how a customer reacts to your product is a matter of psychology. And people who are really into marketing talk about the optimal design of your shop. For example, if you've been reading Mashable, which is the tech website, you find that today Apple have patented, although I had a discussion with one of the intellectual property tutors, they trademark the design. Now, as such, that doesn't make sense. But what they've done is reserved intellectual property for the design of their store. And you'll have possibly seen this when you go into a supermarket and you can smell bread wafting from somewhere. That entices you to walk through the entire store, and it's all a bit manipulative. But it's playing on your particular psychology and your belief set and values, and also your attentional processes. Now, I did mention this in relation to strategy, and that the problem with making a business strategy often is that you have incomplete information. And more so, your perception of that information can be a bit faulty. If you are like me on Twitter most of the day, and I have some followers, it's quite a steady. I tend to follow the same people who follow me, so I have a steady stream of things, some of which are interesting, some of which are not. And same for a product that it somehow has to engage your attentional mechanisms. There's no way your brain can absorb all the information it's given, therefore it has to do something called filtering on the basis of selective attentional mechanisms. That is way beyond the scope of this workshop, obviously. Now going on to pricing mechanisms. I would like to just say at the outset there are three basic approaches in this: cost-based pricing, customer-based pricing, and competition-based pricing. However, these approaches tend to ignore the overall shape of the economy. of your product, whether you're selling a monopoly or you're really in a duopoly or oligopoly. I mentioned the problem about pricing, collusive pricing in utilities and other things. And perfect competition, well, of course, as such, perfect competition really doesn't exist, but this also doesn't stop economists from talking about it. And cost-based pricing is such an idea that you look at how much it makes to cost the product and you add a bit extra, uh, but the maximum you make is a price you sell it for is a price ceiling, and there were limits to you wouldn't be able to sell a Big Mac for 20 quid, even in Oxford Street or somewhere, or rather Kings Road, Chelsea. But you could perhaps sell a equivalent type burger uh, with quite a high profit margin on the King's Road, and your therefore price ceiling might be elevated a bit more, and that depends on the customers to which you're pitching your product to, aka the last slide. Now, penetration pricing, I would like to say at the outset, this is unlawful. So, in other words, I'm not in any way advocating this as a pricing strategy, but so that your uh, uh, price skimming is unlawful. And you'll see in Articles 101, 102 of the Treaty of the European Union that the Competition Act, which transports the European legislation, purposes. This is where you aggressively set a low price and you basically force everyone out of the market. And customers switch to your new product, and it's meant to be associated with increasing your market share, in other words, market entry, or increasing sales volume, and often will be used as a mechanism to launch your product. This depends on a notion called price elasticity. In other words, that the customers are relatively sensitive to the price at which you set your product. In other words, if I add 10p to a cup of coffee, will it be the case that I'll have a certain fewer number of people buying your cup of coffee? Now, if it happens that your customers are totally immune to any of these mechanisms, then your price is said to be inelastic. But anyway, that is somewhat beyond the scope of this particular workshop again. Value-based pricing. Now, I don't know if you've been following the issue about fair trade coffee, and I'm not going to say anything difficult or libelous or defamatory. You'd be pleased to know, and even if I did, I would erase it from the presentation that would be uploaded on YouTube. But it's a notion that when you go to a supermarket, maybe Waitrose rather than Aldi, um, then maybe you might be attracted by a particular brand of coffee which is sold to you as fair trade. Now, actually, a number of economists have done some work on the fact that most of the markup for the product doesn't actually go to the farmers who make the product. And at an extreme, there's a field of marketing called greenwashing, where you basically lie and you make up a lot of junk about the ethics of your product. Now, fair trade coffee is an example of something which isn't as such greenwashing, but where somebody might be more keen to buy that particular brand of coffee because they feel that they're contributing something to a farm in West Africa that maybe they wouldn't achieve if they'd bought own brand coffee or something. This is also called psychological pricing and depends on perceptions of notions of value. And I said previously that predatory pricing is actually illegal under competition law. So it's important to get the two distinguished in your mind. One is legal, the other one isn't. So I'm going to move on to this. Now, how many times have you seen that? Quite a few. And the idea that if you're if as a customer you see your product being sold at half the price of your competitor, you're more likely to shop there. And this obviously is a form of promotion. And promotion is one of the 7Ps, which was flashed up on the slide earlier. Now, if you're interested in public health policy, you'll be aware of the rather bizarre notion that soft drinks manufacturers acting as corporate lobbyists in the Obama obesity policy. But that said, you'll probably be quite immune to my political beliefs that by now, and certainly you will have learned how to ignore them. But certainly, this is an example of Coca-Cola, an incredibly important, profitable company, selling its product in two different guises. And McDonald's do something similar. For example, when they took their product to France, believe it or not, Ronald McDonald turned into Asterisk the Gaul. If you were to buy Whopper, not Whopper, pardon me, sacrilege. If you were to buy a Big Mac in Dubai, then you'd find on offer special pita bread with halal meat. So it's the idea that it's possible to tailor your market according to local need, whilst offering perhaps largely the same product internationally. Now, I will have discussed this obviously in talk number 2 if you came to it on strategy. If you didn't come to it, it's on YouTube. But it's an idea of the difference between multinational and global strategy. Glocal is a term that came out in Harvard Business Review from a sociologist called Ronald Robertson, who coined the term of tempering local effects in the context of global pressures. And you'll see countless examples of this. And it's an interesting phenomenon how you make a product sell in a particular jurisdiction. Yeah. So I really make no apologies for devoting brain substance of this talk to international marketing entry, which is the idea of selling cross continents. And I mentioned previously that BPP are interested in other jurisdictions as are the college law. And it's an interesting thought experiment about how you think you can maximize your chances of selling a particular product abroad. For example, why should you feel your product is attractive to foreign customers there or in your own jurisdiction? And market entry is choosing the timing of your market entry. You'll remember also from workshops 2 and 3 that I introduced the term first mover advantage of being first to market in a particular sector and a particular jurisdiction. And early entry is when you basically get to a particular jurisdiction ahead of anyone else. Or you can choose to have late entry, where you let other international businesses perhaps experiment with the market, and you can learn from their successes or, as perhaps the case may be, mistakes. So this is really getting to the substance of what's happening. An organization wishing to go international fundamentally faces three major issues. One is the subject of this talk, which is marketing. That involves somebody competent in being able to ascertain which market segments you're predominantly offering your product to, how to manage your brand, and branding is a very key important aspect of this, covered on the commercial law course as trademarks. If you did an MBA, you'll do lots of stuff about brand equity, brand value, brand knowledge, brand awareness. Basically, you look at brands really in gory detail. I won't go into that there, but if you're interested, it does exist, branding. And if you get brought for a job in your 30s, 40s, you could apply to be a brand manager. It's a well-paid job, and there are many of them on LinkedIn. Anyway, moving swiftly on, sourcing. Sourcing is where to obtain your products, make your products, or even buy your products. And the third issue is investment and control. Whether you want to have a global partner, whether you want to do a joint venture. If you do a Master of Law, you'll spend 6 months probably studying joint ventures and joint venture agreements. Or else, if that doesn't float your boat, maybe mergers and acquisitions might be instead. And if you do it here at BPP, there's an elective called private acquisitions. And if you have your training contract paid for by a particular firm, you may have to do that elective, whether you like it or not. Cunningham, 1996, identified 5 strategies used by firms successfully for entry into new foreign markets. These are technical, product adaptation, availability, low price strategy. I mentioned penetration pricing earlier, and total adaptation, where you basically make a straight copy of your product in a foreign jurisdiction. Now, again, this book, not to plug the BPP website, is free of charge anyway, if you're a student. This is a book which is core text for the MBA, Fundamentals of Strategy by Johnson, Schultz, and Whittington. And that model is basically a must-quote if you write an song marketing strategy through an MBA, or even if you discuss this in an interview. It's about suitability. How does the strategy effectively address your company mission? Feasibility, whether it's actually practical to make the product or service work. And acceptability, whether it's acceptable to your customers and wider stakeholders, including, of course, your shareholders and committee directors. So I'm going to spend a few minutes now talking about methods of market entry. Not on the slide is exporting, where you basically make the product and then you ship it overseas. And the advantage of this is that you can carry out a strategy which is possibly less risky if you happen to know your home country well. Sending it abroad may be risky because you don't know what works in that particular jurisdiction. The disadvantage is that you can be at mercy of your overseas agents. But I'm going to talk about licensing. A well-known brand is Subway. This talk on marketing paradoxically isn't into any product placement, but it happens that Subway is a well-known license franchise arrangement, which is a method of foreign operation whereby a firm in one country agrees to permit a company in another country to use their manufacturing, processing, trademarking, know-how, or other skill provided by the licensor. It's common to have a franchise agreement. Coca-Cola is another example. Again, as lawyers, you may be involved in drafting up the agreement. If you do, not if you do drafting, you have to do drafting from the Solicitors Regulation Authority, and you'd be aware that when you come on to drafting, you have to be clear in your drafting and set out your objectives for agreements, and you will have done in your GDL the difference between an agreement and a contract, and I'm not going to go through that, but licensing, franchising offers a degree of flexibility, but whenever you have this issue in business, for flexibility, the obverse is control. And be aware of that if somebody buggers up your brand, then customers may blame you at head office for it. An issue of how much you're in control of local operations then becomes not only an interesting one, it becomes a question of your own personal liability as a company for other people's mistakes. Here's the big one, joint ventures. Now, if you rock up to a commercial awareness scenario for a law firm, and you may in fact get something like this. If you have equal partners, it may be more akin to a joint venture type picture. If not, you're maybe looking at a share acquisition type picture. And acquisitions is one zone of the business law and practice core practice area of the LPC. So unavoidable. In other words, joint ventures are defined as follows: an enterprise in which two or more investors share ownership and control over property rights and operation. And it's not uncommon for one partner to bring a lot of money into a joint venture, the other partner to bring a whole suite and portfolio of trademarks, copyright, patents, you name it, different sort of assets. The disadvantages is that often it's a case of yin yang, and the yin doesn't know what the yang is doing. That's why it's very important for there to be adequate communication, and as a lawyer you'd be involved in talking to both parties, make sure that your joint venture agreement matches the objectives of each party and not heavily one-sided. And there ought to be some mechanism for which, if there happens to be any disputes, that your joint venture agreement can easily map out what happens. I'm not going to read out the slide. Obviously, hopefully it's legible. Thanks to you, you're able to see the screen now, unlike before. But just for you to bear in mind, if you were to enter into certain countries like India or China, it is local government regulatory policy, perhaps, well, almost definite, that the only way you can seek approval for this is to have a joint venture with somebody local. That's something for you to bear in mind if you ever wish to expand as a law firm or a client into China. And of course, law firms themselves aren't immune to joint ventures. Lynx did one with Allen and Liddell, which came to an end, it is reported. But if you can follow, Allen and Liddell then went into bed, pardon the term, with Allen and Overy. And another one is this shack-up between Random House and Penguin in the books sector, and if you're considering applying to a massively important firm, Slaughter and May, you'll see that they were in charge of that one. And this current one is pending, if it hasn't already done so, pending regulatory approval 2013. Now, back to Ronald McDonald. The issue about this slide was to produce for you an unthreatening introduction to the concept of purchasing power parity. I'm sorry, you know about my speech impediment, but I'll try to say that again. Purchasing power parity. This is a technique particularly important for pricing in a foreign jurisdiction. Thinking about equivalence of the cost and price of your product in foreign jurisdictions. Yeah, and sadly I'm quite a bit older than you, but some time ago, under also a Conservative administration and Europe, there were some issues about the exchange rate mechanism, how much a product, getting a sense of how much currency is worth, which is of course the purpose of exchange rates, and they thought that the Big Mac, cost of a Big Mac, was quite a good indication to equivalence across different countries. So if you look up the Big Mac index, this was introduced by The Economist magazine as a way of comparing how much something's worth in Venezuela compared to Poland or maybe Hungary. Yeah, here's another bit of shameless product placement. Can you guess what it is yet? It is called Tesco. Every little bit helps. Now, whether you're partial to horse meat or other types of food, of course, horse meat, I wouldn't go on the side right now, but horse meat is a delicacy in certain jurisdictions and therefore commands a different price compared to an everyday. I'm not saying anything defamatory in case you're worried. It's well reported that horse DNA was found in certain everyday burgers from Tesco. Tesco obviously extremely angry that this happened, and I'm sorry, I don't know why I'm laughing, but I find the concept inherently quite farcical. But anyway, it's an important operational issue. This again is something to do with reputation and brand value. In other words, when I mention Tesco, you don't think of horse meat. You think of perhaps their excellent products and their excellent range of everyday value products. But that said, it's well recognized that Tesco's profits have been flagging a lot, in fact. And why has this gone wrong? Well, of course, many postmortems have and will be done on it. And one of them has been on what happened, what went wrong with the Tesco value range. And obviously, think about problems which have happened in your local jurisdiction, probably have a bearing on how well you're going to sell it in China, Thailand, or India. And it's sort of the uh, appetite, if you pardon the irony, for grocery in foreign jurisdictions is at least as substantial in India, China, Thailand as it is here in Watford if you get the right products. But uh, again, going on to reputation, arch lefty Politomi has talked about uh, employment issues in Tesco, not just confined to Tesco. And obviously, nobody wants to have a notion that your corporate is using cheap labour for obvious reasons, particularly if it is untrue. And some people think that this sort of marketing, especially in their age of social media, is particularly poisonous. And you can't really control it. And it's thought that one of the possible, and there are many reasons why Tesco may have underperformed, is that it's lost sight of its core market. And I'm struggling to think of what his core market was because it's diversified so much. You remember that I talked about the Ansoff matrix in strategy in the second talk. Well, if you think, is Tesco's core thing against 7Ps is uh, I don't know, melon slices or cabbages, or is it banking, or is it Tesco Law Services? Ironically, uh, even though it's called Tesco's Law, Tesco, to my knowledge, never wanted to do legal services as yet, as approved by the SRA. So that's another issue aside. Or are they well known for selling petrol? If you diversify into too many areas, then you can end up with the being a victim of brand dilution. In other words, nobody actually knows what you're good at. And this is a problem uh, I'll try to avoid any examples close home. But if you had a shop that's well known for making personal computers, should it then go into wacky tablets, or should it go into uh, MP3 players or something? Well, you can end up alienating your core market by going into other areas, or it could end up being a big success. So that's that about protests in real time, of course, when things break to happen in real time. If you were anywhere near Twitter today, you see that some people who were dismissed by HMV, of course, sacked is an emotionally loaded word, but they weren't dismissed, and they took to the Twitter airwaves and caused mayhem. And obviously, that is your corporate's worst nightmare if you just have a loose cannon as your mouthpiece, and it causes big problems, particularly if this is happening in real time, and you, as chief marketing officer, you have no real control of the fact that your company is trending for all the wrong reasons. So that brings me on to the very last topic of Commercial January, and thanks for sticking with it. I hope you found it interesting at two levels. One is to help you get a job, but the second level is actually three reasons. Second reason is here's what you could have won, which many of you will be breathing a sigh of relief, thinking, thank God I never did business studies at university. But the third thing is that I hope you find it actually quite interesting and opened your eyes about reading, if you ever got a chance, The Economist or The Financial Times or Legal Week, and all these things that legal recruiters want you to read, and you don't really see the point of reading there. The point about it is that if you understand the world of what these people do day in, day out, until 3 in the morning, then maybe you'll get a sense of what works and what doesn't work. And finally, social networks. And here's an article from my blog, The Antisocial Network. And there's a lot of fuss about law students and lawyers, law firms. I'm followed by about 4 or 5 QCs who tend to be much nicer than middle grade lawyer for some reason, legal journalists, and you can argue that this has been a great democratizing force for getting knowledge and ideas spread amongst people across the industry. But you'll also be aware that as law students, that it's been alleged that certain law firms maybe will look you up on Facebook or Twitter or LinkedIn or something. And if they see an embarrassing, compromising picture of you somewhere or some dodgy thing on Google, then they may kindly just prefer not to interview you. So it's a double-edged sword. You can either get yourself well known or even well known for the wrong reasons, and I'll let you independently make up your own mind where the law firms stand with their use of social media. Now, there are guidelines for law firms about their use of social media, and if you're interested in regulation law, which I perversely am for reasons which form the scope of this workshop, the Bar Council and Law Society have guidelines for legal professionals and their use of social media, which you may find useful or not. So that wraps it up. Thanks for your enormous patience. I really do appreciate it. Obviously, this setup for workshops has not been easy to do because I've been rather selective about the topics I wish to present to you. But if it's any consolation, they're largely what you do on any MBA in the core curriculum. And that certainly will be way beyond what you expect to know through your vaccine interview or training contract interview, apart from perhaps your particular interview where you're the unlucky one, where you get caught by an expert in this area. So, by the way, before I go, it's probably worth bearing in mind if you're applying for a firm that happens to be amazing at joint ventures or acquisitions or that type of vehicle, that's probably worth you knowing something about it in case they happen to present it to you as your commercial awareness scenario, which I could do, of course, on the sly, to check whether you know what their particular strengths are. Certainly, I know it has been done to me and others. 1, 7Ps, 2, market segmentation. 3, I've sort of given you a noddy view of cost-based pricing, competition pricing, value-based pricing. 4, the world is not flat, but certainly there are issues involved about whether it's great that you have free-mooned persons, and some of you will be very expert in free-mooned persons from having studied it in enormous detail, or whether you should think it should be British jobs for British workers, and that's again what the scope of this you'll be happy to know. The penultimate point was international market entry. What works, what doesn't work? Tesco, in certain jurisdictions, has been nothing short of a fiasco. And why things went belly up, perhaps in America or China, is of interest to you, particularly if we happen to be the law firm that's instructed you, is Tesco's. So you obviously need to know what is good in their strategy, what doesn't work. And at the final point was social branding and networks. Networks relates to the network theory of innovation. And it's thought that if you have more things done on the internet, e-commerce, globalization is more likely, and therefore local markets do not exist really, because what you're selling is freely available across the whole world, and that's where the jurisdiction of your particular commercial agreement becomes very important, and certainly beyond the scope of this workshop. So that's it. Thank you very much.